Hey, Matt, I think we can go ahead and get started. Um, let's see. Welcome, everyone. Hopefully, everything is working and everyone can hear. This is the second in a series of 4 workshops. So last week, we reviewed government benefits. And tonight, I'm excited that Matt Gooden and I will be bringing you information on guardianship and also ABLE accounts, which is a more recent development. And we're going to start with guardianship and then follow guardianship about midway through this evening with ABLE accounts. So we actually have 2 presentations in one evening. So Matt's going to lead off with the focus on guardianship. On the way to doing that, let's see, a couple of housekeeping items. I believe we have a chat this evening, which we did not have last Tuesday. So let's see here. They would find that, let's see, yeah, if you click on more, if you have your kind of table of contents up at the edge and then click on chat, then that will provide you with the opportunity to record questions, make comments, that type of thing. So hopefully everyone finds that. We're regret that was not an option last week, but that was one of the improvements we made for the second and future sessions to make the chat available for you. And then in addition to that, Matt and I are of course on this evening and will present. And I once again want to not only recognize all the parents that are joining us, but we also have our parent advocate with us. Shannon, are you there?
I'm here. I made it.
Okay. All right. Terrific.
Facilitate questions in the chat.
Yep. So this is Shannon Penaflor, our parent advocate and a parent of JP with special needs. And some of you may have received an email or made contact with Shannon, but Shannon is facilitating the follow-up free consultation that we're providing to all the participants in the series this month. And so her contact information will be in an email coming to you tomorrow morning, Wednesday morning, as it did last week. And that's the opportunity to thank you for participating this evening, to give you Shannon's contact information so that you can take advantage of the free follow-up consultation. And then also to remind you if you haven't already, to register for next Tuesday's workshop, which is going to focus on special needs trusts. Really exciting topic. So let's see here. Let me make sure I've got the chat box up so that I see any comments that are recorded. And let's see here, try to get that off to the edge if it's possible. Oh, well, that didn't work too well. Okay. All right, well, there we go. All right, so Matt, let me see how we're doing volume-wise. I want to make sure, okay, we're good there. All right, so leading off this evening, be Matt Gooden on guardianship. So Matt, if you want to jump in, and thanks so much for being here for all of us.
All right, thanks, Gordon. Thank you guys for being with us tonight. For those that weren't with us last week or who don't know me, my name is Matthew Gooden. I'm a special needs attorney in Louisville, but I assist clients across the state. Our practice focuses on estate planning for families who have dependents with special needs. Like Gordon, I have a personal connection to the special needs community. My sister Rose has Down syndrome, and I coach Special Olympics. So both of us have a personal and professional connection to the special needs community. Tonight we're going to talk about guardianship, but before we get to that, I briefly want to thank Down Syndrome of Louisville um, and Julie, the executive director, for helping.
Matt, people are saying they can't hear you very well.
Okay, I'll turn up my
Closer to the
volume.
mic.
Yeah, I'll turn up my volume all the way.
There we go.
Okay. So I briefly want to thank Down Syndrome of Louisville and Julie, the executive director, for helping make this series a success and being willing to share the information about this series to not only the Down syndrome community, but also the broader special needs community as well. So Julie, if you're on, thank you for that. So let's jump into guardianship. In speaking with families over the years, there are a few common misconceptions about guardianship. They primarily focus on what guardianship is, what it involves, and particularly when it's appropriate. So as we go through, we're going to touch on those and hopefully get some clarification on those misconceptions so that you guys have the up-to-date information and you can make informed decisions on whether or not guardianship is appropriate. So let's go to our agenda. And Gordon, do you have the controls?
There we go.
All right, so we're going to start off with basically talking about what guardianship is. We're going to talk about the important terminology related to guardianship. We're going to touch on some Kentucky specific rules for guardianship. We're going to talk about the types of guardianship and the guardianship process generally, how to appoint a guardian, the liability of a guardian if they're not doing what they're supposed to do. We're going to talk about removal of a guardian, and we're also going to talk about termination of guardianship generally. And then at the end, we're going to talk about alternatives to guardianship. And I think that's probably the most important topic that we'll talk about, because in many cases, the alternatives to guardianship could be appropriate in the situation, and many families don't recognize that. So generally, what is guardianship? Guardianship is a serious legal proceeding that takes away rights of an individual to do certain things and to make certain decisions. So it's a very serious proceeding, which is why we want to carefully consider the alternatives before we pursue guardianship. Guardianship is a legal relationship between a capable adult, the guardian, and a ward. Ward is the term that's used in Kentucky. We're going to use the term protected person. Ward is a very dated term, but the protected person is the person for whom the guardianship was obtained. So by legal relationship, we mean that you have to go through court in order to obtain guardianship. It's a court supervised relationship, and there are legal duties and responsibilities that come along with it. In most states, the law presumes that individuals 18 or over can make their own decisions. They can do what they want. So that's the magic age. That's the age of majority in Kentucky. So once you achieve that age, you're presumed to be able to make your own decisions, and you don't need guardianship unless there are some other factors in play. Some families feel that it's necessary to apply for guardianship to protect their loved one with special needs, and we'll talk about the viability of that as we go through. So some important terms to know. The protected person, again, in Kentucky, it's referred to as the ward, but that's the individual for whom guardianship is sought. That's the individual with special needs. The petitioner, that's the person who files the initiating forms to begin the guardianship process, and we'll talk about what those forms are in a few minutes. The respondent, it's the same person as the protected person, but it's the legal terminology to refer to them. It's the person for whom guardianship is sought. It's the person with special needs. On the forms that you have to file, it'll list petitioner and respondent. The respondent is the person with special needs. Guardian or conservator, that's the person or persons, if there's multiple individuals who are appointed by the court to handle the protected person's affairs. The guardian is responsible for the care, custody, and control of the person. If they're also the conservator, they're also in charge of that person's financial resources. The conservator is the person that's responsible for only the financial resources of the individual. It can be the same person, and in my experience, most of the time it is the same person. But there could be situations where it's a different person serving for the guardian and another person serving for the conservator. There is a limited guardian that could arise, and that's the guardian that has fewer powers and duties as the full guardian, and those powers and duties are specifically listed in the court order, so they have limited decision-making authority. Lastly, the term trustee, not directly related to guardianship, but we're going to talk about it as an alternative to guardianship. So trustee, important term to know, is the person who has the power of administration over trust property. It has a legal obligation to administer the trust according to the trust document. We'll touch on that more in a minute. So guardianship is very state specific. Guardianship depends on state law, regulations, and state practice and norms. If you're seeking guardianship advice, it should be related to the state in which you live or the state in which presumably the ward or protected person lives. So you should seek local legal counsel to get your state's specific information. As an example, in 2018, or prior to 2018, Kentucky was the only state that still required a jury trial when making a disability determination in a guardianship proceeding. So a jury had to find that the individual was disabled and therefore a guardian was needed. We were the only state left that still required that. In 2018, that requirement was waived. Now a bench trial is permitted. That's where the judge decides. They make the determination, not a jury. A bench trial is permitted if all the parties agree, there's no objection, and all the interdisciplinary team members agree that the individual is disabled or partially disabled. So just an example of the state-specific rules and laws. So the types of guardianship, at the outset, no matter what type of guardianship you're in, they can be temporary or permanent. So keep that in mind. But there are two types of guardianship: full guardianship and limited guardianship. The full guardianship is where the guardian has comprehensive decision-making authority and the responsibility over both the person, the protected person, and over their legal and financial affairs. So they've got full decision-making authority over just about everything. Contrast that with a limited guardian, where the guardian only has decision-making authority and responsibility over selected decision-making. So in Kentucky, one thing that sometimes I hear from families, they recognize that the guardianship proceeding is very serious and they don't like the idea that their loved one could lose several rights. So they're leery of full guardianship, but they also believe that their loved one needs assistance with decision making. So they file for guardianship with the idea that they're going to get limited guardianship. That can be problematic because in Kentucky, the determination on what type of guardianship you ultimately get is based on the interdisciplinary team report, and it's also based on the judge. Those are the individuals that are making that determination. So you can go into it wanting limited guardianship, but there's not a guarantee that that's going to be the ultimate outcome. So that's an important thing to keep in mind. And it's another reason why we caution pursuing the guardianship option prematurely. So lastly, the joint point. It's not a type of guardianship. It's just recognizing that more than one individual can share guardianship authority. You can have a co-guardianship arrangement in both the full and the limited guardianship context. So the guardianship process, just a few details. First, there are filing fees. So keep that in mind. In Kentucky, important point, no personal checks are accepted. I don't know if that's the case in other states, but in Kentucky, no personal checks. And also to that filing fee, if there are two people filing, so one person is filing for guardian, the other person is filing for standby guardian, which we'll define in a moment, or if two individuals are filing as co-guardians, there are two separate filing fees, so that number is double. So keep that in mind. The forms which have to be filed to start the guardianship process are listed here. ALC 740 is referred to as the petition. Basically, what that says is, I think this person is disabled, and here's why. ALC 745 is the application for appointment. Basically, you're saying to the court, I want to be appointed this person's guardian or this person's conservator. ALC 034 is a personal identifier sheet. It just lists identifying information on the respondent, the individual with special needs. The inquiry into qualifications, that assists the court with vetting the individuals who apply to be guardian. So it's basically just making sure that you're a suitable candidate to serve as guardian or conservator. So it's a little bit of your background information and things like that. Transportation agreement, basically it's just saying that you agree that the respondent will be available for the evaluations, and they'll be available for the guardianship hearing. And then lastly, the designation of process agent, only if the petitioner is not a resident of Kentucky. Doesn't come up very often. Some last miscellaneous items. All the forms have to be typed or legibly written in blue or black ink, and all applicable forms must be signed and notarized. I will say with COVID, some of the requirements have been waived, specifically the notary requirement. Right now, the court is accepting forms without the notary. Basically, you just write on the form, due to COVID, unable to notarize or something to that effect, and they're accepting that. How much longer they'll accept that, I'm not sure. And that might not be the case across the state. In Jefferson County, we're operating under that assumption. Other parts of the state, that might not be the case. So to be safe, if you can get the items notarized, that's the better practice. And then lastly, you'll have to provide proof of the respondent's social security number when you file all of these documents. So once all the forms are filed and the fees are paid, the county attorney's office will review the petition and determine whether or not the case should proceed, generally very informal. Assuming it's approved, the court will then appoint an attorney for the respondent. That's the individual with special needs. And this person is referred to as the guardian ad litem. They will represent the respondent throughout the process and advocate for their best interest. The court will also schedule a hearing date, which is typically 60 days after all the forms are filed. And the court will appoint an interdisciplinary team, which consists of a physician, psychologist, and social worker. And then each member during that 60-day window will schedule an evaluation of the respondent, and they'll each file a report with the court prior to the hearing. At the hearing, the county attorney will, quote, prosecute the case. And prosecute is a little bit misleading. In most of the cases, at least in my experience, everyone's on the same page. Everyone's in agreement that the individual is disabled, that they need a guardian, guardianship is appropriate. So there isn't typically an adversarial nature, but sometimes there could be. But the county attorney does prosecute the case. And at the hearing, at least one member of the interdisciplinary team will testify at the hearing if they're all in agreement. Typically it's one. If there's disagreement, they may all need to testify, and the petitioner may have to testify depending on the judge in the situation. So I'm going to look at these. I will get to the questions here once we get to after the guardianship. Before we turn to the alternatives, I'm going to touch on the questions that we've got in the chat box. So hold tight on those. In terms of appointing a guardian, again, this requires proof to the court that the person isn't able to care for themselves, they aren't able to make or look after their own affairs, and it requires a physician certification. This is all going to come in the form of that interdisciplinary report that's submitted to the court. In some states, other agencies may have to be involved. For example, in Kentucky, the social worker is involved, so that could be an example. All interested parties have to be notified. So on the forms, there will be a section for notice. In essence, it's close family members who are over the age of 18, so just keep that in mind. But it can be waived. And then the court, again, appoints someone to represent the individual during the proceeding. That's the guardian ad litem. They validate that the appointment is in the best interest of the individual. And the guardian's powers in dealing with the protected person's property is carefully restricted by law. Again, it's a legal relationship, legal duties and responsibilities. Moving to liability of the guardian. So because the guardianship is a legal relationship, like we said, there are legal duties and responsibilities that the guardian has to follow. If they're not following those, they could be subject to legal liability. So the guardian has to use reasonable care and caution when making decisions and doing things on behalf of the protected person. But unless the guardian is acting negligently, unreasonably, or irresponsibly, they're not generally personally liable for the actions that they take on behalf of the protected person. So absent those three things, generally not personally liable. But a guardian could be liable for their actions if it results in damage to the protected person's property due to careless acts, so negligence, or if the guardian is personally or intentionally at fault. So there are some situations in which they could be liable for their actions. Moving on to removal of the guardian. So a guardian can be removed by the court if they're not properly performing their duties. So that's pretty straightforward. That makes sense. They can also be removed if they become incapacitated, if they move out of state, if they're not filing their annual reports like they're supposed to, or if the court deems the removal in the protected person's best interest. So there are a variety of ways that the guardian could be removed. If the guardian is removed, a successor will be appointed, and the successor guardian again can also be appointed if the first guardian resigns or dies. One thing that I do want to add here, a standby guardian is something that could be pursued when the individual applies to be guardian. A standby guardian basically is a person appointed by the court to step into the shoes of the guardian if anything happens to the guardian, if they're removed, if they die, if they become incapacitated, or if they resign. That often makes things a little bit more efficient. If something does happen, the court has that person. They've already been approved. They just step in and start serving rather than the court having to go find someone and appoint them as a successor. So termination of guardianship. Guardianship, again, generally terminates when the protected person reaches age 18 if the guardianship was established prior to age 18. So this comes in the context of the guardianship was established because the individual was a minor. So for example, if something happened to both parents and there was a minor child, there could be a guardianship that was put in place that would terminate once the individual turned 18. Or it could terminate if the protected person marries before age 18, or if they move out of the house and they're living on their own and they're supporting themselves. That could also be a reason to terminate the guardianship. Guardianship also terminates when the protected person is no longer incapacitated. So if they no longer need help to make decisions for themselves, it would terminate. If they pass away, obviously it would terminate. In the case of a conservatorship, the estate, the conservatorship would terminate once the estate is exhausted, or if the estate is less than the statutory minimum for the state. And the guardianship would also terminate if the protected person moves out of state and there's a guardian appointed in that other state. So the old state, the guardian in the old state, that guardianship would terminate. So
yeah, we have some really good questions. I just wanted to interrupt and ask before you continue down the path. So
Yep.
someone wants to know the cost for a team
So
to be
typically,
evaluated, interdisciplinary team. What does that cost approximately? And then I have another question unrelated.
typically these costs are covered by the court. there wouldn't be any cost to the petitioners. The only cost to the petitioners would be the filing fees for the forms that we discussed, a recording fee for the disability judgment at the end after the hearing. And if they were represented by an attorney, presuming they charged a fee, that would be in there. But in terms of the interdisciplinary team, there wouldn't be a cost unless it was shown that the guardianship was pursued and wasn't necessary, that it was pursued basically as a waste of time. That could be an issue where the cost could come back to the petitioner.
Great, that is good news, I think, to everyone. And then the next question is, a couple of people are asking about wanting info about these annual reports and taxes. Can you explain more about this annual report? What do they report to, et cetera?
Yep. So the good thing about Kentucky, a lot of this stuff is form based, and you can access it online. You can go to the court's website and get the forms that you need. But one of the requirements is an annual report. Basically, it's filled out. I think it's a few pages long. It just updates the court on the protected person status, has their needs changed, has their living arrangements changed, et cetera. It also gives a brief accounting of their finances and things like that. If you're a conservator, you will also have to do a financial report every 2 years. So it's very form based. It's not something that you just have to create on your own. You can get the form. You have to file it every year, and it's basically an update to the court on the protected person's status. All right. Any other questions so far? All right. So we will move on to the alternatives to guardianship. Before I get there, I do want to point out this is where one of the main misconceptions about guardianship arises. It involves the appropriateness and the need for guardianship in general. So I hear many times parents say, I've heard that once my child turns 18 or leading up to age 18, I have to go file for guardianship. And that's not always necessary. Many times it will be necessary, but in many instances, it's not necessary. And some of the alternatives to guardianship could have been appropriate. So don't assume that guardianship is necessary simply because your loved one has special needs. The need for guardianship is going to be based on several factors. One, the individual's ability to make certain decisions, their living and family arrangement, and then also the other supports that they have available to them. So again, many families are incorrectly told that or believe that they should or must pursue guardianship. And in some cases, one or more of these alternatives would have sufficed and would have assisted with decision making, but also wouldn't have come with the restrictions that guardianship does on the individual's rights. So guardianship should only be pursued after careful consideration of each of these alternatives. So keep that in mind. That's the main takeaway from our presentation on guardianship. So moving to the alternatives, there likely several of these will be involved. It won't be just one. Many of these will likely be in place. The first is a representative payee, which many of you are likely familiar with. The healthcare representative, that's a medical power of attorney, durable power of attorney, specific power of attorney, a trust, potentially, a special needs trust could be alternative to guardianship, protected proceedings, potentially, and then lastly, parental powers if the individual is under 18. And we'll touch on that lastly. So we'll go to representative payee.
Let's see.
There we go. So the representative payee is the person that's authorized by Social Security to receive and manage federal funds for a person who is unable to manage their own funds. So this person doesn't have any legal authority to make personal decisions for the individual. Their authority is strictly in managing the income from the federal agency. And this is available for SSI, supplemental security income, which we talked about last week, or other Social Security benefits. So many of you may already be familiar with this. You may already be a representative payee for your loved one with special needs. It's important to remember separate records should be maintained, and that the representative payee shouldn't mix their own funds with the individual's funds, so no commingling. Um, and that periodic accountings may be required by Social Security, so it's important to continually maintain detailed records of your activity and how the money was used. I would recommend making a spreadsheet where at the top you have the benefit, the income that comes in, and then below that you have a breakdown for different categories of expenditures. So maybe utilities, personal expenses, entertainment, things like that. At the bottom, you have total expenses, and then the difference, you carry that forward to the next month. After a few months, it'll be pretty easy. And what this will do, if Social Security down the road requests information, you can easily access it. You don't have to potentially go back a year and try to figure out what the funds were used for. So it'll just make your life easier. Moving to the healthcare representative, this is also called the healthcare surrogate. And this comes in the context for a medical power of attorney. Your healthcare surrogate is your power of attorney for medical decision making. So this person is appointed by an individual who feels that they lack or may eventually lack the ability to make decisions for themselves related to medical decisions. So the healthcare surrogate is authorized to make medical decisions for the individual, and they can also access the individual's medical records because they would be the individual's personal representative under HIPAA. But it's important to note that with the medical power of attorney, with the healthcare surrogate, and with the power of attorneys that we're going to talk about in a minute, the prerequisite to being able to use these alternatives is capacity. The appointment of a power of attorney has to be done when the individual is competent. They have to have legal capacity to execute the document. And what we mean by that is they have to have a basic understanding of what the document is, what it's doing, and that they're giving someone decision-making authority in the various contexts, whether it's medical or financial and things like that. So that's an important bar that we have to cross at the outset for any of the power of attorneys. And a related document to the healthcare surrogate is a living will. This document, again, requires capacity, but it's a document that states the intent of the individual if they're ever faced with a terminal medical condition. So it covers artificial food and water, life-saving treatment, organ donation, and things like that. So it's a document that often works in tandem with the healthcare surrogate. So the durable power of attorney, again, we have to have capacity. So that's our first hurdle that we have to cross. But a durable power of attorney is a legal document that allows someone, the principal, to designate someone else, the agent, to make decisions and handle the financial affairs of the principal. So it's a principal-agent relationship. And the person designated, the agent, is often referred to as the attorney in fact. The appointment can be effective immediately, or it can become effective upon a future occurrence. Typically, that future occurrence is the principal's incapacity. So it's a springing power of attorney. It doesn't come into effect unless the principal becomes incapacitated and unable to make decisions for themselves. It can include the power to receive federal checks. So our representative payee, handle bank accounts, buy and sell real estate, and make healthcare decisions, again, medical POA, if it's joined with this. A whole host of powers can be included in the durable power of attorney. It remains in effect despite incompetency or disability. So that's the durable nature. And the power, the authorization ends when it's revoked by the principal or the individual with special needs passes away or the agent passes away. So keep that in mind. It's important when the power of attorney context, the individual with special needs that's executing the power of attorney still retains the ability to make decisions for themselves if they choose. It's just giving someone the ability to assist them with decision making, and the individual with special needs is still free to amend that and to revoke that authority if they choose.
Matt, I had a question, or rather one of our amazing families here had a really good question. Can the individual be a payee? And do they have to keep records?
And I'm assuming we're talking about the individual with special needs. Can they be?
Correct.
I don't believe so. I don't know off the top of my head, but I don't believe they can. And I don't know if Gordon knows a definitive answer to that, but I don't believe they can.
Typically, while a minor, they can't. And then once they become an adult, it's back to dealing with the capacity issue. This actually came up today in a situation with a grandparent where the grandparent, in essence, is a custodial parent, and the biological parent is still the legal guardian, and the biological parent is receiving the SSI and isn't being too helpful with the expenses for the grandchild, for the grandmother. So so there's going to be a conversation with Social Security this week on that, and may need an attorney if things become more difficult. So so this issue of who controls the SSI is a somewhat fluid one. I'll be happy actually to next week when we talk about Special Needs Trust to find out how the situation developed, because that project's going to take form this very week. So so we'll have an update on some of the representative payee options and questions. But there is responsibility that goes with being the representative payee to take care of these things. And and subject to audit, used to be Social Security wanted an annual reporting, and now it's similar to taxes. It's kind of a random, to keep everyone on their toes type of audit situation. The other thing is, you may or may not be aware, but Social Security actually electronically monitors the representative payee accounts. And they monitor that to see that funds are not accumulating in there, that they're being used for the intended purpose. And in addition to that, if the representative payee account exceeds $2,000 at the first of any calendar month, Social Security is subject to determining that as a month of ineligibility and, in essence, claiming payments made for being returned to Social Security. So it's quite a topic.
I have a couple more questions, Matt, if you're ready. So first of all, does an attorney need to prepare a durable power of attorney?
Yes. There are always online things that you can do. You can come up with just about any legal document online, but that comes with its own pitfalls. So if you want it done correctly and you want to avoid problems in the future, the best route would be to have an attorney draft those documents for you. So yes.
That makes sense. And then I'm just going to read, Melissa had a question here. I'm just going to go ahead and read it. Does our guardianship paperwork trump a hospital opinion or rule on us being allowed to stay with the individual in an emergency situation or COVID or whatever the sickness may arise during this time when everything is stricter? So does our guardianship paperwork trump a hospital opinion or rule on us being allowed to stay?
So we're kind of in a state of limbo. So with COVID, obviously it's been very new. It's changed a lot of normal practices for a lot of different things. So guardianship pre-COVID, the guardian, their decisions and what they say pretty much trumps everything else. So they do have pretty broad authority. With COVID, however, since it's considered a national pandemic, and the rules are strict, so that it protects the broader society as a whole, it's debatable whether or not the guardian would be able to trump, so to speak, the hospital rules if they have rules in place that limit access to the individual or limit the amount of people that can see the individual. Given the fact that they're operating under the assumption that there's a national pandemic going on, it's a health crisis, and they're trying to limit that. Given the nature of that, it's debatable whether or not the guardianship would be able to trump those rules. I would tend to think that even despite the guardianship, you wouldn't be able to get around those rules. It's unfortunately some of the difficulties that we're dealing with during these times. Pre-COVID, you would have a better argument. Right now, not so much.
Okay, that's all so far for right now.
All right. So moving on, we just talked about durable power of attorneys, and they can be very general. Now we're going to focus on specific powers of attorney. Again, we have to have capacity. So the individual with special needs has to meet that capacity threshold. Again, it's a legal document that allows someone to designate another individual. And in this case, they're designating them to make specific decisions or manage a specific asset. Generally, this is in the context of a bank account. And assuming the individual is competent, they have the capacity, sometimes the bank can provide a form to carry out this, and you don't have to have a specific power of attorney, but you could also have an attorney draft the specific power of attorney for the specific item, whether it's a bank account or some other item. So the specific power of attorney is preferable to a joint account because a joint account creates an ownership interest for the individual being added to the account. So there are some risks that come along with that. Just adding someone to the account so that they can assist you with managing it exposes the account to that other person's creditors potentially. If they file for bankruptcy or if they have a divorce, you're potentially exposing that account to those events. So it's more preferable to have a specific power of attorney rather than a joint account arrangement. So just keep that in mind. So a trust is also a alternative to guardianship, and in our context, it's going to be a special needs trust. But a trust is a relationship where property is held by one party, the trustee, for the benefit of another party, the beneficiary, and it's created by the owner, sometimes called the settlor, the trustor, or the grantor, depending on where you're at. And that this person transfers property to the trustee, and then the trustee holds that property for the trust beneficiary and administers the trust according to the trust document. So for our purposes, we're just talking about a special needs trust, and this is a trust that's established for the benefit of a person with special needs. And the special needs trust may, among other things, receive assets such as an inheritance, a court settlement, insurance claims, gifts, life insurance policies. It can hold many different assets. It also protects current and future government benefits eligibility. That's the key part of the special needs trust for our purposes. And it can also pay for a variety of things. It can pay for medical care. It can pay for special equipment, education, entertainment, transportation, and a whole host of other things. And we're going to touch on this more, obviously, next week, because that's going to be the entire topic is special needs trust. So we're going to go into this in much more detail. And there are different types of special needs trusts depending on the situation. So more on that next week. Protective proceedings is also, in a sense, an alternative to guardianship. This would arise in the context of child protective services or adult protective services. If someone were to contact them and make an inquiry and they had an investigation and the court became involved, the court could, on request and without the appointment of a guardian, could issue a protective order for a minor or an individual with special needs, and thereby protect that person or that person's property. The court could also direct that a trust be established for that person. So it's another way that could eventually lead to some protection for the protected person and their property, just a different way to get there. And then lastly, parental power. So it's important to keep in mind that, again, our age of majority is age 18. So up until that point, parents, assuming the individual hasn't married and is still living at home, the parents are the de facto decision makers for the children. So they've got the decision-making authority. So guardianship really doesn't become necessary, if at all, until after the individual turns 18, and the parents can either jointly or individually execute on behalf of their minor child things like consents, waivers, and even powers of attorney. Many of us have signed these, waivers to do certain activities and things like that. So keynote, up until age 18, parents have that de facto decision making. After 18, you're presumed to be able to make decisions for yourself. So that is all we have on guardianship. Any questions on that? All right, so we will move to ABLE accounts, and Gordon is going to talk about ABLE accounts. They're actually referred to as stable accounts in Kentucky. At the end, if anyone has questions, if they think of questions as we're going on, again, feel free to add them to the chat box. I will stay on for 5 or 10 minutes afterwards if we need to and answer any questions. So Gordon, take it away.
Very good. Thanks so much, Matt. Great job on guardianship. Appreciate the detail, kind of the behind the scenes workings of that. I switched to a new PowerPoint. Is it showing up for everyone? Okay, wonderful. Thank you. Well, I'm really excited to talk about the ABLE Act and ABLE accounts, and as Matt said, stable accounts in Kentucky. It's a more recent development in special needs, and you may have heard some about ABLE accounts, but I'm hoping this evening we go into a bit more detail so that you get a more accurate read on what they are, what they're not, advantages, disadvantages, the application of ABLE accounts, and what situations maybe don't work so well for ABLE, and actually what situations fit with ABLE like a glove. So here we go. Again, we're not all things to all people. We work hard, but have to make that disclosure. So ABLE Act overview. First of all, technically, the name of the ABLE Act was changed to the Stephen Beck Jr. Act. And for those of you that do not know of Stephen Beck passed away in his 40s. He was both spouse and parent. His daughter, Natalie, part of the Down syndrome community. And this ABLE Act was his brainchild, and he advocated for it for close to 7 years. And literally on the eve of its passage, he passed away, almost as though he had to hang on until he saw this come to fruition. So a very special story there. A few years ago, I spoke at the ARC National Conference, and I did a workshop. In fact, part of what we're looking at this evening, though I've updated it substantially, but I did a workshop on the ABLE Act. And so several people at the conclusion of the workshop came up to thank me for the information, asked a question or two, and among those that came up afterwards was Mrs. Beck. And it was really such a special moment, and she just let me know how much she appreciated ABLE being talked about and how incredibly important it had been to her husband and so forth. So very cool. It came about as a result of the Tax Increase Prevention Act of 2014. And the law created the ability for states to implement and make it possible for individuals with disabilities to have a tax-free savings account. And these were modeled after 529 college savings accounts. So 529s came about some years earlier, as many of you know, the opportunity to set aside funds for what started to be college or higher education, and then was further expanded to include via the Tax Cut and Jobs Act of 2017. It also became possible to use 529 accounts for secondary education, this type of thing, not just college, but early on for private schools, parochial schools, that type of thing, to also help with technical school and a variety of things. So it broadened the 529 substantially. But the ABLE accounts, or ABLE Act, was patterned after that because, like 529s, ABLE accounts grow tax-free and they distribute tax-free as long as they're used for purposes designed by the legislation, just like 529s used for education-related expenses. Legislation has been passed in most states, so most states have ABLE accounts now. Not all. Wisconsin is an example of a state that doesn't. Some states that don't have contracted to use other states' ABLE accounts so that their citizens have options, even if there's not a quote unquote home plan. The ABLE RNC, which stands for ABLE National Resource Center, so www.ablenrc.org is a great resource to go to learn more about ABLE accounts. The Tax Cuts and Jobs Act of 2017 brought enhancements to ABLE accounts, and we will cover those enhancements, the last major update to ABLE accounts, and we'll cover those changes this evening as well. Let's see here. Okay, we've already have our first question, and it's: how would a large amount of money gifted to a special needs child benefit under an ABLE account? Okay, hold that. We've got examples where we're going to talk about that and just what the limitations are of ABLE. Let's move forward. Eligibility. So who's eligible for an ABLE account? So generally, the individual must be blind or disabled prior to the age of 26. In some cases, if a diagnosis occurs prior to age 26 that will result in death, disability, death or disability such as spina bifida, hemophilia, muscular dystrophy. So the person was diagnosed with, they know they have the condition prior to age 26, but the condition has not rendered them incapacitated before 26 relative to the Social Security definition of disability. They are in most cases still eligible for an ABLE account because the origin of the diagnosis or condition was prior to age 26, even if it has not affected them so significantly they're drawing Social Security benefits by age 26. A person can be over 26 when opening the account, again, if the origin or the diagnosis or the disability occurred prior to age 26. So as an example, I had someone in my office this week who suffered a TBI, a traumatic brain injury, in her early 30s. Well, prior to that, no disability, no diagnosis, et cetera. And so she is not eligible for an ABLE account because there is no origin of her disability prior to age 26. If the age criteria is met and an individual is already receiving SSI or SSDI benefits, they're automatically eligible. So again, diagnosed before 26 and drawing Social Security benefits, automatically eligible. If the age criteria is met and the individual is not receiving benefits, so diagnosed prior to 26, but not yet either eligible for or drawing Social Security benefits, then it's a matter of looking at whether their situation meets the criteria for Social Security, and then confirming diagnosis, such as through a letter from a physician. Okay, ABLE account limits. So this will kind of get to the question that was introduced by one of our participants this evening. The maximum annual contribution to an ABLE account is $15,000 generally. This is limited to the annual IRS gift tax exclusion amount, meaning the amount that any individual can gift to another person without having to file a gift tax return, pay any type of taxes, etc. And so it has been $15,000 for a while. I suspect in the next couple of years, it'll advance from 15 to 15.5 or something like that. But this represents the amount that an individual, basically a person giving, per person receiving. So as an example, I had a meeting recently with a physician, and he and his wife were doing some gifting to one of their children to assist them in purchasing a home. And so in that case, between the two of them, they could jointly give $30,000 per year under the current limits. So that's been used as the annual maximum contribution limit for the ABLE accounts. There is an opportunity to contribute more than that, and we'll talk about what that exception is in just a moment. Maximum account balance is $100,000 for SSI recipients. So if an individual is drawing SSI or expects to apply for SSI, they're going to want to keep their ABLE account balance under $100,000 because at that level they cease to be eligible. So if they have $100,000 or more in their ABLE account, they would not be eligible for SSI. If they're currently drawing SSI and their account rises above $100,000, then their benefit would be suspended until which time the account is spent back down under $100,000. That's for SSI. For Medicaid, it's different. It's the maximum 529 college savings account plan max, which for Kentucky is $350,000. If anyone is on board this evening from Indiana, it's $450,000. And so quite a bit higher for Medicaid. But again, if there's SSI involvement, we have to keep focused on the $100,000. If the SSI recipient's ABLE account goes over, as we indicated, they'll be suspended on SSI. There's only one ABLE account per person. So unlike 529 college savings accounts or education accounts where every grandparent can open an account for a grandchild, in the case of ABLE, so that they can monitor and make certain that they're not over contributed to each calendar year, the consumer can only have a single account. As many people as you want can contribute to it, as long as all contributions combined in a calendar year do not exceed the $15,000. Contributions, again, can be made from anyone, the beneficiary themselves, that is a consumer. If they have money themselves, they can put it into an ABLE account. So it's not limited to parents or just family members, but it can actually be the consumer's own money, the individual with special needs or disability. Family members also, friends, etc. And they must be made in cash, meaning ABLE accounts are not set up to receive property, or like nonprofits occasionally say donate a car or that type of thing. ABLE accounts receive cash. They do not receive property or items other than cash. Okay. Okay, so another question. I may be getting ahead, but can money be taken from SSI amount and put into an ABLE account? SSI is typically considered for food and shelter. My suggestion would be that if one is receiving SSI and there's some amount of SSI left over after their food and shelter expenses are covered, I see no reason why it could not be deposited into an ABLE account. Just as in large back payment situations, Social Security funds can be placed into a what we call a first party or self-settled special needs trust. So again, primarily Social Security for household or food and shelter expense. But if there are funds left over, let's say one's monthly contribution to household expense is 600 and they're drawing 794, the limit for 2021, that excess could be stowed away in an ABLE account in an effort to keep their available resources under the $2,000 maximum, which is required for both SSI as well as Medicaid eligibility. Okay, enhancements made to ABLE accounts. And this is where we get into the exception for contributing more than the 15,000. So tax and penalty-free rollovers of up to 15,000 from a 529 account. That is, parents that may have set up a 529 college account for a child, and then things as a result of the special needs, it's determined that perhaps higher education or a college or something is not in the offing, then the 529 account can be rolled over to an ABLE account so that the funds could be maintained indefinitely for the benefit of that child with special needs. Typically, the rollovers are counted as a contribution. So if there was a 529 account that had 10,000 in it that was rolled over to an ABLE account, then there would be an additional 5,000 that could be added in that calendar year, because the $10,000 rolled over from the 529 would represent 10,000 of the 15,000 for that year. Rollover of certain retirement funds. This is brand new, really cutting edge, but rollover of certain retirement funds may be possible. As an example, let's say that a consumer with special needs gets a part-time job, maybe at Walmart or something, and they're able to participate in the 401k. So they payroll deduct some money and they have the employer match added to it. And then at some point they decide to part company. Well, what are we going to do with the retirement account? Because when one leaves employment, of course, it becomes available. You can cash it out. You can, under normal circumstances, roll it over to an IRA, et cetera. And so in the case of an individual with a disability or special needs, they really don't want to have access to those funds, because then it's counted as an available resource and it would be cause for them to lose eligibility for SSI, Medicaid, waiver services, et cetera. And so under some circumstances, and this is on a case-by-case basis, but at least be aware that it may be possible if it's less than the 15,000 or 15,000 plus their earned income for that year, which we'll talk about in a moment, they may be able to roll it over to an ABLE account so that they can retain the savings, but not run into eligibility issues for their means-tested benefits. Now, a question just came through that said, can a 529 account be counted against someone receiving waiver services, et cetera? Boy, that's a question that comes up all the time, and I appreciate asking about it. Generally, the answer is no, it does not count against them, as long as the 529 account is not what's called a UTMA or custodial account. That means it's UTMA or custodial typically means it's been funded with the consumer's own money. So as an example, let's say that a kid with special needs had a babysitting job or a paper route or something, and they saved up a couple of $1,000s and put it into a 529 college account. If it's their money, the child's money that went into the account, then typically that account is set up as a UTMA. Also, if a young person were to inherit funds and they were placed into a 529 account, usually, again, those are Uniform Transfer to Minor Act accounts. And those are a problem with benefits because as they become an adult, they take charge of the funds. So it's money in waiting for them. The parent can only exercise control over those funds for a brief period of time until they're at age of majority. So, but as a rule, as long as 529 accounts are not UTMA or custodial accounts, they do not represent an issue with benefits because the parent is the owner and controller of the account, but they can change the beneficiary so that it's a sibling. The parent can actually change the beneficiary and make themselves the beneficiary. It is possible for the parent to be both the participant or owner of the account and the account beneficiary. So, so generally no problem with those, but do keep an eye out for the rare but occasional UTMA accounts. Another question came through, where does special needs trust deposit large amounts? And another question was asked, well, that was about the 529 and benefits. So, okay, two things. As a general rule, 529 accounts do not create a problem with Medicaid or SSI, as long as they're not UTMA. Of course, ABLE accounts do not create a problem with SSI or Medicaid. That was one of the reasons why they were set up. And then as far as monies that are put into a special needs trust, or an ABLE account for that matter, there is a range of investment options available. So funds in an ABLE account do not have to sit there earning 0.000% interest. There are investment options within the ABLE account. And then with regards to a special needs trust, there are a broad range of investments available for funds that are in a special needs trust. Those include mutual funds, exchange traded funds, stocks, bonds, and in fact, a special needs trust can own property, a vehicle. There's just about nothing that immediately comes to mind that a special needs trust cannot own or hold, that a person cannot own or hold. So you have a very broad range of options with regards to a special needs trust. In fact, I'm in the process of working with a family where we're looking at the special needs trust holding a limited liability company that actually will employ the consumer with special needs. So we're doing some, what I call some really cool cutting edge stuff these days as we figure out ways to use these tools in more and more ways to advocate for our consumers with special needs. Let's see. What if someone leaves something to our adult unexpectedly that is going to put them over the allowed 2,000? What do we do in that panic moment? Okay, well, the first answer to the question is yes. If it puts them over $2,000, you are in a bit of a panic. Typically, it needs to be dealt with in the month of receipt. So the first word of suggestion I would make to someone that is inheriting in a situation like that, and that would be to prevail upon the executor who's going to be cutting the check to do so on the first of a month, so that you have the benefit of an entire calendar month in deciding what you're going to do with the funds. If they cut a check on the 28th of the month, that's really not a good thing because as the first of the next month rolls in, they're on SSI, you're potentially creating a period of ineligibility. And then while Medicaid is a little more patient than SSI, you're also potentially creating an ineligibility issue relative to Medicaid and waiver services. So what can you do? And we're going to get to that, I think, in the next two screens. Okay, so there's a credit for qualified retirement savings contributions. So a person may, if they file taxes, may be eligible for a earned income a credit by putting the funds into an ABLE account. And then here is something, again, recent with the 2017 Tax Act. Account holders with earned income enjoy a higher contribution limit. In addition to the annual $15,000, they can contribute up to the lesser of their annual earned income, or $12,760. So that means if they had a part-time job and earned $5,000 in that calendar year, their contribution limit is $20,000, 15 plus the $5,000 of income. $10,000 of income, their limit is now 25. But there is a cap as to how much income is considered. But that does create a higher opportunity for contribution. Also, if you're at the end of a calendar year, you can, in essence, almost double dip. That is, at the end of the calendar year, you could put 15 in, and a couple of days later, January the 2nd, 1st or 2nd, another 15 could be put in. So, so ways, again, to, in essence, set funds aside that do not create an eligibility issue with benefits. We're almost to some examples, which is going to play into some of the questions that have been asked. But in case you're curious, this is the lengthy list, although not all inclusive. This does give you a flavor of how broad these ABLE accounts can be used for. And this has expanded over time. It was initially considered to be somewhat restrictive, but over time, the regulations have become a bit more lax, and the last kind of takes the cake. And I had the opportunity actually to walk through this presentation today with the director of the ABLE accounts for the state of Indiana. And so that was a great experience. And one thing that we added as a result of that was enhances health, independence, or quality of life as it relates to their disability. So, you know, if going to Disney World is going to help their mental health, then I say as soon as we're comfortable with flying, let's get on the plane and go. Okay. ABLE account payback, and then we'll get to examples. I appreciate your hanging in there with me. There is a payback provision because the consumer's own money is welcome in an ABLE account, meaning their inheritance, their savings, their wages, their SSI, because their money of most any type is welcome in an ABLE account. There is a Medicaid payback. And what that simply means is that upon the death of the consumer, if God were to call them home, then the balance left in the ABLE account is potentially available to the state for capture to reimburse the state for Medicaid benefits afforded them while they were living. However, notice the last bullet point, and that is implementation of the payback provision is on a state-by-state basis. Therefore, just because the Medicaid payback provision exists, do not automatically assume that the state's going to wipe out the account upon the death of the consumer. It's on a state-by-state basis, and I suspect it will also have something to do with just how strained Medicaid is in that respective state for funding. Because if it's a matter of a 10-year wait for a Medicaid waiver, if you catch my drift, it would seem that the state might be a little more inclined to enforce the Medicaid payback because obviously there's not enough Medicaid funds to go around. One thing to keep in mind though with ABLE, look at the second bullet point, and that is because the consumer's money can go into the ABLE account, even though grandparents or parents or other parties may contribute funds that they had a choice as to what to do with. Unfortunately, even funds by other parties, such as parents, grandparents, et cetera, do get caught up in the potential Medicaid payback. So there's no distinguishing at the death of the consumer that, oh, 10,000 of this came from the individual with a disability and the other 20,000 came from family. It is all potentially subject to Medicaid capture via the payback provision. So keep that in mind. As a result of that, some additional items here. ABLE accounts are developed and managed on the state level. States can decide to contract with another state to establish, administer their accounts. The ABLE Act requires that any state that establishes a plan must provide adequate safeguards to prevent excess contributions. So the government is very keen at making sure that one doesn't put in more than they're eligible to. Individual can enroll in the state's program if the program accepts out-of-state residents. And as an example, Kentucky has Stable, Indiana has Invest Able. Virginia may seem random, but Virginia has what's called Able America, and it is the one ABLE account in the country that is advisor assisted. And it's through American Funds. Many of you may be familiar with American Funds. So in the case of that, and that is available to people nationwide. And so if you want the assistance of an advisor in picking investments for the ABLE account and doing the paperwork to set it up, et cetera, then the Virginia ABLE America may be the plan for you. Neither Kentucky or Indiana offer specific state tax incentives. So in essence, you're not tied to Kentucky or Indiana, as the case may be, by some special tax incentive unique to just you who lives or resides in one of those states. So you're basically free to go to any plan in the country and enjoy the same tax deferred accrual, the tax-free distributions, et cetera, be it the Virginia American Funds plan or other states as well. And more people are, seeking the help of an advisor as ABLE accounts have gotten a little more complicated. Okay, opening up an ABLE account. Okay, we got another question. My husband is a financial planner advisor and can help with such things too. Fantastic, good. Okay, state determines the enrollment process. Enrollment and maintenance of the account is primarily done, we've got a little repetition here, primarily done through the individual state ABLE program. The Kentucky and Indiana both have online sites that you can go to. Some allow enrollment by mail or by fax. Indiana and Kentucky is generally online. Depending on the state, there may be a minimum contribution to open the account. And of course, there are fees. I mean, there's always some amount of fees to pay for those that are helping you with the account. And then some programs offer a prepaid or debit card. Indiana, as an example, does offer a debit card as a part of their program. And there is the National Resource Center. Okay, the website, www.ablenrc.org. And on that website, you can actually compare different states' plans to see what the different minimums are, what the fees are, this type of thing. It's quite a resource. Again, www.ablenrc.org. Okay, things to consider. And now we're into what may be a good fit for ABLE and what may not be. So what may not be the best fit for an ABLE would be inheritances, settlements, judgments, or contributions from family or beneficiaries that exceed the maximum annual contribution limit. So we have to keep that $15,000 in mind. So it's typically not suitable to list as a beneficiary on a life insurance policy where the funds may exceed $15,000. If a person gets a $25,000 judgment, it's not a good fit for ABLE. You got a $15,000 max. So got to keep the maximum in mind. Number two, contributions are not coming from the individual with a disability, meaning they're coming from grandparents or aunts or uncles or friends or a godparent. Those don't have to go into an ABLE account where they would be subject to Medicaid payback. They could instead go to a special needs trust that we're going to talk about next week. Beneficiary who incurs disability is older than 26, such as that TBI I was mentioning, Lou Gehrig's disease, ALS, stroke, muscular sclerosis, etc. So where the origin of the diagnosis, that is, perhaps occurred after 26, another example where ABLE is not a good fit. The beneficiary cannot make financial decisions. May not be best for the consumer to have an account if they would struggle with how to handle it or take care of it. And then ABLE accounts can be used in combination with other savings vehicles such as special needs trusts. A person can have both. Okay, we're finally to the examples. Sorry for the long wait. Better suited for small settlements, unexpected inheritances, or savings of the consumer. These are ideal situations. Another question came up in Kentucky. How long does it take to open an account for an eligible individual? I would say probably an hour going online to enter the data and get the account set up. These are pretty quick. And you can actually enter the routing number and account number of the respective institution that you want to transfer funds from. And so this can come together pretty quickly. I've had people in my office that, it's kind of like we're at the end of the calendar month and we've got to get rid of the money like now. So these can happen pretty quickly. All right. So again, better suited small settlements, unexpected inheritances, or savings of the consumer. So think of it as a put and take or save and spend type of account. So examples where it can be very useful. Example one, grandparent dies, and this is a question that came in the chat box, the unexpected inheritance, the panic. Grandparent dies and leaves $10,000 directly to each grandchild. Spend it. So one option to get rid of the $10,000 to get back under the $2,000 for Medicaid and SSI is to spend it. Go on a wild spending spree and spend it all in a hurry. Number two, you could prepay final expenses. But, if you're dealing with a teenager or somebody in their 20s, it may not be terribly exciting to be prepaying final expenses at that point. So there's always ABLE. And again, same day you can get an ABLE set up. You can get the $10,000 swept out of whatever account it's in into the ABLE account, and the person's back under their $2,000. So it can be really helpful in those situations. Example two. Okay, incident at school results in a settlement of $15,000 for your child. And I've seen these, I'm sure you know of individuals that have been affected where perhaps the person that's non-ambulatory in a wheelchair, there's an accident with a wheelchair, or the wheelchair rolls out of the out of the school bus, and the individual may be injured on the road. There's just all kinds of things. I think there was a situation recently where some medications at school were misadministered, and a class action and a settlement to each student, et cetera. So when these settlements are less than 15,000, an ABLE account is just a very quick and easy way to set the funds aside for future use, where they'll grow tax-free, can be distributed tax-free, and you'll have minimal expense in setting that up. Number 3, consumer has earned income. That is, our individual with special needs or a disability has a job, has maybe part-time employment or something, and they want to save it for a vacation, for furniture, for additional schooling, maybe a vehicle, etc., while still keeping their SSI, Medicaid waiver, etc., able to the rescue. No reason why they can't save monies that they're earning at work for future use while maintaining eligibility for all of these benefits. Okay, a couple of more examples, get just a little more complicated, but ABLE accounts within limits can address resource issues by sweeping the inheritance, legal settlement, paycheck 529, savings or investment account into an ABLE account. The consumer is back under $2,000. And what an ABLE won't fix, though, are income issues. So let me give you another example or two. I've had plenty of parents come in, and they want to apply for a Medicaid waiver, or their child's being targeted for the waiver, but there's a $5,000 savings account. And clearly that $5,000 is going to make them ineligible for that waiver, Medicaid, SSI, et cetera. An ABLE account used to be, we in many cases had to spend the funds quickly. ABLE account gives the opportunity for those funds to be preserved for that person for the future, and in essence, immediately be eligible for benefits. There's no look back, there's no delay period, need not be a period of ineligibility. It is not looked at as though they're giving the money away or creating again an ineligibility period. Really very exciting what can be done. 2 examples here. Example 1, consumer age 22 is receiving SSI and has a part-time job earning $500 per month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in their SSI. So this is the formula for SSI reduction, 500, and we talked a little bit about this last week, less $85 in income that's forgiven, leaves 415, and that would mean a $207.50 reduction in their SSI benefit. So putting their paycheck into an ABLE account will keep them under $2,000, but it is not going to prevent SSI from recognizing that as income for calculating or reducing their SSI benefit. Another question, when the individual wants to take money out, do they need to report what the money is used for? Records should be kept in order to help ensure that the program maintains its, in other words, eligibility to maintain it. So obviously with a debit card, one can spend, and it's not as though you're asking for approval before the funds are spent, but there should be some records kept as to what the money is used for, so that there's not a problem down the road in terms of how the account was handled. Okay, keeping an eye on the clock. I think we can get there in about 5 minutes. Okay, example 2, consumer age 35 is receiving $500 per month in Social Security disability benefits from their own record of employment. And as we discussed last week, all they have to have is part-time employment to become eligible to draw Social Security disability. So they're getting $500 a month from themselves, from their own disability record, while they continue to work. They are also receiving adult child benefits of $1,000 per month from a parent's record. And yes, that's correct. They can draw off of their own record and draw off of a parent as well. So in this case, they're drawing $1,500 a month in Social Security disability benefits. They continue to work, earning $900 a month, which is under the substantial gainful activity limit. So it's okay to do all of this. They can have $1,500 a month in Social Security and $900 a month in income. So we're at $2,400 a month. Pretty exciting, I'd say. They can save up to $25,000 $800 per year in an ABLE account. That's the 15,000 annual contribution limit plus their earned income, which is 10,800, 900 times 12. So they can save up to $25,800 per year to an ABLE account to keep their countable resources under 2,000 to maintain their Medicaid and Medicaid waiver. But back to the income issue, this will not fix their exceeding the monthly max of $2,382 for disability Medicaid. So in this case, as a precursor to next week, they would need to set up a Miller Trust, and we'll be talking about Miller Trust, what we call D4B Miller Trust next week, because believe it or not, in example 2, this person can have it all. If they set up a Miller Trust to set aside the excess over the 2382, they can do all of this. They can have disability Medicaid, they can have Medicare, they can have Medicaid waiver services like the Michelle P, they can have Social Security disability, they can have earned income. Yes, it's possible to have it all. I just really get excited because knowledge is power in this case. Okay. And then special needs trust, we're going to talk about next week. So, but ABLE accounts and special needs trust complement each other. It doesn't have to be either or. It's more tools in our toolkit. I'll just kind of move on from this slide in light of time, because we're going to really get special needs trust covered thoroughly next week. And if you think there's not enough to talk about, there are multiple types of special needs trusts, and we're going to have a lot of fun sorting out the different types of special needs trust and what they can do, because it's really important to get the right trust. Getting the right trust is almost like getting on the right plane. If you get the wrong one, it's not going to turn out so well. So I think you're really going to enjoy next week when we unpack special needs trusts and what are they, where they come from, and the different types of them. And again, special care is the program of support for families, which includes coordinating with a special needs attorney like Matt and financial planner like myself to address all these issues comprehensively for families. Okay, 801. Wow. Okay. That was a lot to cover, but what fun! What fun to review and share all of that with you. Again, contact information for myself and for Matt on the screen, and then you'll get an email again tomorrow morning from Down Syndrome of Louisville with Shannon's information. Shannon Pinafore, our parent advocate, may still be on with us. I don't know. And that will be to facilitate your follow-up consultation, which is free, absolutely free, costs you nothing. We'll do it in person here in the Louisville office. We'll do it by Zoom if you prefer. But as you can see, there's a lot here, and we want to make sure that you, your family, and your loved one with special needs is getting the full benefit of all of this. An email will go out again tomorrow morning, and then another email next Monday, like before today's, reminding you to make sure you're all registered and in good shape. Matt, do you want to tag in at the end here?
Just thank you guys again for being with us this week. Hopefully you'll be with us for the next couple weeks. I do have a handout that's front and back on stable accounts. It's specific for Kentucky. So if you want that information, I can provide it to you. So if you send me an email or give my office a call, I can email that to you if you want. It's got a lot of the helpful information that Gordon touched on. So with that, thank you guys, and hopefully we'll see you guys next week.
All righty. All right. See you next week. Bye.